Professor Guiora has spent 19 years in the Israeli Defense Forces Judge Advocate General's Corps, retiring with the rank of Lieutenant Colonel. He held a number of senior command positions, including commander of the IDF School of Military Law, Judge Advocate for the Navy and Homefront Command, and the legal advisor to the Gaza Strip. He's testified before the Senate Judiciary Committee, advocating the establishment of a domestic terror court in the U.S. Professor Guiora was also an expert witness at a hearing before the House of Representatives Homeland Security Committee's Subcommittee on Intelligence, Information, and Terrorism Risk Assessment. He's been interviewed and published on CNN, Washington Post, PBS, New York Times, Los Angeles Times, BBC, C-SPAN, Christian Science Monitor, and Fox. And now Google. He can add to the list. He's currently a professor of law at the S.J. Quinney College of Law at the University of Utah. I was under strict orders to not make this too long, so I'm going to actually cut it short there, and I'd like to give a warm, googly welcome to Professor Guiora.
Thanks, Ben. Good afternoon. When I set out to write this book called Constitutional Limits on Coercive Interrogation, what drove me was my 19 years experience in the Israel Defense Forces, which has led me clearly to the understanding that there must be limits on how we interrogate detainees. When we talk about limiting how we go about interrogating detainees, it clearly implies the following assumptions. One, that we have to interrogate detainees. Two, that interrogatees have rights. And three, that the state has rights. And so the question is, how do we go about balancing those equally important rights of the state and of the individual? And not only is my book premised on my 19 years experience in the Israel Defense Forces, but it is also, frankly, based on my analysis of the past 7 years, what I call the post-9/11 world. Because when I examined interrogations in the context of the post-9/11 world, my deep concern is very much so that we have not clearly articulated the limits of how we go about interrogating those who we detain. But before we start talking about the rights of detainees, we have to go one step backwards, or at least one step backward, and ask ourselves, who are these detainees? What are they, and what rights are they to be granted? The traditional theory has been that they are either criminals or that they are soldiers in a prisoner of war paradigm. I suggest that they are neither, that rather what they are is what I call a hybrid paradigm. And a hybrid paradigm suggests just that they are neither criminals nor soldiers. They are something in the middle. And something in the middle means that they have certain rights as criminals, certain rights as soldiers, and it ultimately means that we have no choice but to articulate, create, and ultimately implement an entirely new paradigm, because this post-9/11 world is an entirely new paradigm. Furthermore, I also suggest that interrogations are the heart and soul of operational counterterrorism, and therefore the hybrid paradigm must be adaptable and adoptable for these post-9/11 detainees. So first of all, who are these people and what are they? I suggest that they are terrorists, and then the question we have to ask ourselves is, what is terrorism? So if you Google this, you will see that there are hundreds upon hundreds of possible definitions of terrorism or terrorists. But here's my suggestion. Terrorists are individuals and or groups who are bent on killing innocent civilians, harming innocent civilians, or causing property damage to innocent civilians for the purpose of advancing a cause, political, religious, social, or economic. Rule number one, however, in the context of operational counterterrorism, is that terrorists have rights. And what does that mean then in the context of constitutional limits on coercive interrogation? Is that the terrorists have rights. The detainee has rights. It ultimately means that the detainee is no more than an individual suspected of being involved in terrorism. No more and no less. Again, critical to understand, he is no more than a suspect. On the other hand, the state has the absolute obligation and responsibility to protect all of us. And to those means, it has to be able to get information from that individual. How then do we go about balancing And how then do we go about actually implementing, and how do we go about interrogating? To complicate this even more, you have to view this from the perspective of a triangle, where the first step is how do we go about detaining? What are the reasons for detaining someone? Step number 2 is what happens in the interrogation. And step number 3 is what do we do after we've interrogated, i.e., where do we go about trying the individual? I suggest that the only way that a discussion like this can be held is by also looking to see how other countries go about conducting their operational counterterrorism, because the reality is that no one nation has the best answer. Working my way backwards, where do we go about trying? Because you can't interrogate without knowing what the end game is. I suggest the establishment, I propose the establishment, and Ben mentioned I testified in front of the United States Senate Judiciary Committee. I propose the establishment of a domestic terror court whereby individuals accused of involvement in terrorism would not be brought either to military commissions in Guantanamo, would not be brought to traditional Article III courts, as we know, civilian courts in the United States, but would be brought before what I call domestic terror courts, which would be created especially for the trying of terrorists, Americans and non-Americans alike. The hybrid paradigm model is primarily based on how in Israel the legal aspects or the judicial aspects of operational counterterrorism are conducted, because it is a myriad of both an administrative process and of a legal process. In the domestic terror court model that I propose, the state would charge someone, and the charge would be based on both in criminal evidence, as you know it from Law and Order and the other TV shows, and also from intelligence information gleaned from the interrogation. However, that intelligence information cannot be presented in a court of law, at least not in front of the defendant, because it is classified information, meaning that the defendant won't have the right to confront the source who gave the information about him. So viewed as a two-track approach. On the one hand, there'll be criminal evidence, and on the other hand, there will be intelligence-based information. His attorney can cross-examine with respect to the criminal, cannot cross-examine with respect to the intelligence. Working our way backwards, what is the role of the interrogation process in all this, and why the constitutional limits? Because ultimately, when the detainee is being interrogated by the interrogator, here's what you must understand. You must view the interrogation setting as not only what happens in that cell itself, not only what happens between the interrogator and the interrogatee, but it is far broader than that. From the perspective of the interrogatee, the moment that the jail door is closed, that's when the interrogation process begins. And the limits that we must impose on the interrogators includes the entire, what I call interrogation infrastructure, the interrogation apparatus, in order to protect the rights of the individual. From a constitutional perspective, there are 3 critical amendments that are relevant to this discussion. They are the 5th Amendment, the 8th Amendment, and the 14th Amendment. Again, TV shows, Law and Order, Miami Vice, Miami Hot, all those others. All of you have known since 4th grade something called Miranda, correct? All right, so the question is, in the context of operational counterterrorism, does an individual suspected of involvement in terrorism, does he have the right to be Mirandized? I break this down into 2. In the context of a soldier arresting or detaining, say, Osama bin Laden, I don't think any of us would expect that the soldier would Mirandize bin Laden. You know, Mr. bin Laden, you have the right to remain silent. On the other hand, I would suggest in the context of constitutional limits on coercive interrogation, that if bin Laden were to be brought in front of an interrogator, bin Laden must be Mirandized. So again, it's a mix and a match. It's the hybrid. It's a little bit of this and a little bit of that. Because I do believe that in going forward in terms of how we interrogate, because I really am a deep and passionate believer in limits must be imposed, and Mirandizing the detainee is step number 1 in articulating these limits. Step number 2 is the 14th Amendment, due process. There can be no lawful interrogation unless there is a process in place. Process in place implies limits, which is precisely the heart and soul of this entire discussion. What are those limits? We'll talk about in a bit. And the 8th Amendment, in terms of excessive punishment, what's important here to understand is I would suggest that placing individuals in solitary confinement violates their rights. Does that mean we cannot ever place someone in solitary confinement? I would suggest in the ideal, no. Is it sometimes effective? Maybe. If it's unlimited, is it unconstitutional? The answer is yes. 5th, 8th, 14th, Miranda, due process, and excessive punishment, cruel and unusual punishment. Why are these necessary? Because if you track where we have been in the past 7 years, I would suggest that the interrogation regime developed and implemented by the United States government has been largely, I would suggest, one, illegal, because it has been torture-based. And if it is torture-based, it is ultimately immoral. And it is both immoral and illegal. It is ultimately ineffective. What does ineffective mean in the context of operational counterterrorism intelligence gathering? It means that the information we receive is not actionable. And if information received is not actionable, it means that the state does not have enough information on which it can act operationally. And if the state doesn't have enough action on which it can act operationally, then when it does act, it's acting on misinformation or disinformation, lack of information, and then ultimately the operational measures will be ineffective. On the other hand, when the interrogator conducts his interrogation and is able to receive intelligence information that is accurate, that indeed enables operational counterterrorism. But what are the measures then in the context of coercive interrogation? What are the limits of coercive interrogation? Look at it as viewed as a spectrum. On the far extreme is torture. I would argue and have argued and will continue to argue that torture is illegal, torture is immoral, and torture does not lead to actionable intelligence. There have been some who have suggested that there be something called the torture warrant, whereby the executive branch would go in front of a court and ask for a torture warrant. I suggest that sounds good, immoral, illegal, and does not lead to actionable intelligence. There are those who also suggest that in the ticking time bomb scenario, that torture is justified. Based on my 19 years experience in the Israel Defense Forces and thousands of hours spent with interrogators, interrogatees, in countless intelligence settings and in detention cells, I would suggest that the ticking time bomb is a Hollywoodized version that does not really reflect reality. It does not justify torture. Torture is out. On the other hand, the traditional criminal law interrogation is, again, from Law and Order and so on, is, I suggest, not going to always be applicable nor relevant in the post-9/11 world. So we need to find an alternative, something else. And that something else goes back to the hybrid paradigm, and that is the essence of coercive interrogation. Now, when I start speaking about coercive interrogation, I appreciate the fact that some of you in this room, you all have hair, I don't. Your hair will immediately go like this. Fine. But at least what I do suggest is that we begin the process of having a reasoned discourse and debate about what additional interrogation measures, lawful, we can implement. In the context of torture, no. Traditional criminal law interrogation, also no, or at least not always. So we need that alternative. Coercive interrogation measures, as I define them, suggest the following. That if the interrogator has determined that he's convinced that the detainee knows something, but that the detainee is not cooperating with him, he or she, the interrogator, requests permission, written permission, from the head of the relevant security agency, in the American context, the CIA, in Israel, it's the General Security Services, written authorization to apply additional measures. What are these additional measures? One is placing a sack over the head of the detainee. 2 is loud and cacophonious music. 3 is sleep deprivation. 4 is sitting in a uncomfortable chair. And 5 is playing music and modulating the room temperature, so hotter, a little bit warmer, a little bit cooler. But there are 2, or actually 3 critical buts. 1, these measures cannot be implemented unless the head of the agency authorizes them in writing. It is all about responsibility and accountability. There is, in my paradigm, no more nod and a wink, and there is no more, well, we said this, but we meant that. Condition number 2 is that present in the detention center is a physician who is not, underlined, not in the chain of command of the interrogators, meaning that if the physician says no, no is no. And number 3, all these measures are time sensitive, meaning they can be implemented only for a certain amount of time. Why do I think that these additional measures are successful? I suggest that these additional measures are successful primarily predicated on my experience, which I referred to earlier in the Israel Defense Forces, having seen these measures implemented. I think that when done in a limited fashion, based on these conditions, that you can argue, and I would argue, that they are effective. But do we need to implement them at all times? Is there a free license to the interrogator? The answer is no. They can only be implemented if the interrogator has determined that he needs them and if there's written authorization. Is there a risk here that there will be free license? I would suggest primarily because of the requirement of written authorization, and if somebody engages in excess, either the interrogator or the head of the agency, that precisely because of the argument relating to accountability and responsibility, they would be criminally liable. So there are checks on this additional right to conduct a coercive interrogation, and intended to balance between, again, the rights of the individual and the rights of the state. Does this mean that every detainee will hereby cooperate with the interrogator? The answer is no. Does this mean, though, that this additional measure may well contribute to more successful interrogations in a lawful context? The answer to that, I would suggest, is yes. How do we go forward, and what do we need to do? First of all, I would suggest, I've stated before and I'll say it here, that as I was writing this book, word got out amongst interrogators, and I received a number of emails from interrogators in Afghanistan and Iraq who very much wanted to meet with me because they wanted to tell me the following 3 things. 1, that they had seen individuals waterboarded. 2, that they themselves had never waterboarded. And 3, that they knew that waterboarding was ineffective. So from my perspective, one of the principal audiences of this book are precisely those individuals who ultimately are interrogating on our behalf because they need our protection. When I say they need our protection, we must establish a rights-based interrogation regime that protects both them and enables them to get the information while simultaneously protecting the rights of the detainee while also enabling the interrogators to get information from the detainees. Working our way backwards to the final step of the triangle, I told you there was 3 parts to this triangle, obviously. 1 is the trial, 2 is the interrogation, and 3 is the detention. How and why do we detain people, and how is that related to interrogations? Clearly, X number of people in the post-9/11 world have been detained based on information received from a source, and those sources have been wrong, obviously. Some people have been detained, and their detention was justified. What is critical in the interrogation process is that the information received enables us to arrest those who need to be arrested and to not arrest those who we need not arrest. Why? Because ultimately you have to view this from the perspective of allocation or misallocation of resources. In a cost-benefit analysis of counterterrorism, if we send the cavalry to arrest people who we need not arrest, then we will be letting those who need to be arrested, we let them go free. We will not be emphasizing, we will not be targeting the appropriate people, all predicated on information that turned out to be wrong. So where does all this leave us in the context of coercive interrogation? It suggests that we absolutely must establish a paradigm that is lawful, that is moral, and that is effective. If we don't do any of these 3, not only will we not be the beacon on the hill, but we will, frankly, not be able to gather intelligence that will lead us to conduct operational counterterrorism. In the context of establishing a domestic terror court based on this coercive interrogation regime, the primary idea is to enable the bringing of defendants based on evidence and on intelligence information, and enabling to try them or convict them fairly. not based on the military commissions, but based on a fair judicial process. There can be no fair judicial process if the interrogation is illegal and if the interrogation does not lead to actionable intelligence. One of the realities of the past 7 years, which is directly related to this coercive interrogation paradigm, is that in many cases the interrogators did not have enough or sufficient information about the detainee. That is, they were in many ways groping in the darkness. And if you do not have information about the individual you are interrogating, if you are language challenged, if you are culturally deficient, or if you don't have enough information as to who you're you're interrogating, then ultimately the information you receive will simply be inaccurate. Working our way backwards even more. A coercive interrogation regime, precisely because it enables the interrogator to apply additional measures, must be implemented only under extreme care and caution, and only when the interrogator is absolutely convinced that he must apply these additional measures. Are these additional measures torture? Are these additional measures unpleasant? And what are ultimately these 5 additional measures? I would argue, have argued, and will continue to argue that they are not torture. They don't in any way meet whatever definition you want to use of torture. They are, however, additional measures. They are coercive. They can be viewed as coercive, and most importantly of all, from the perspective of the detainee, they must be viewed as coercive. Here I add in parentheses, the media, for instance, refers to waterboarding as the simulated death of the detainee. I would suggest from the perspective of the detainee, as he's having pictures of water poured into his throat, his death is not, from his perspective, his death is not being simulated. His death is imminent. So when we talk about coercive measures, we must view it not from the perspective of the interrogator, but how it's perceived by the interrogatee. What is his thought process or her thought process with respect to these measures? Some have suggested that by articulating these openly and publicly, the detainee knows what's coming. He knows that various measures will be applied with respect to him. True. Not only have I written about this, but maybe, I think more importantly, the Israeli Supreme Court in a very important case from 1999 also articulated what measures yes and what measures no. So there are those who suggest that by articulating this openly and clearly, the interrogatee knows what's happening. He knows what's coming down the road. Perhaps. The assumption is that interrogatees go off to battle well prepared for interrogation. Even if they do, and we are going to assume that they do, and in spite of that, X percentage of them clearly give relevant, actionable intelligence in the context of interrogation. Those who don't, and here's the big and, if the interrogator is convinced that there's reason to apply those additional measures, that is precisely and exactly when the coercive interrogation regime comes into place, predicated on this entire idea of constitutional limits, which reflects the balancing equation. How to go forward? If we're going to agree, and some of you will agree, some of you will disagree, that the past 7 years have not, I would argue, have not been overwhelmingly successful in developing and implementing a balanced approach to operational counterterrorism, the question is, how do we go forward? What do we do next? The first thing I suggest we do is that we agree that we must absolutely balance between various rights, the rights of the state and the rights of the individual. If we are unwilling, unable to articulate the need to balance, then the next X years will be just like the past 7 years. The next step in this is to articulate openly that all operational counterterrorism, including the coercive interrogation regime, must be predicated and subservient to the rule of law. Rule of law above all. And there can be no exceptions. There can be no by all means necessary or any of those other catchphrases which are nothing more than creating an exception regime and which leads ultimately to violations of the law, not to speak of morality. So rule number 1 is balancing. Rule number 2 is understanding the rule of law. Rule number 3 is clearly stating to ourselves that we are going to conduct ourselves morally. And rule number 4, problematic to state, but relevant and accurate to say, that there will be days that terrorists will succeed, There will be days that we will succeed. There is no winning the war on terrorism. We will never win this war. It is not a war. However you want to define it. In Israel, it's referred to as armed conflict short of war. Terrorism will never be defeated. And if you accept the premise that terrorism will never be defeated, and on the other hand, you accept the premise that the state has the responsibility to protect all of us, then the coercive interrogation paradigm fits that like a hand onto a glove or a glove onto a hand, because it enables a balancing, subservient to the rule of law, and enabling the state to go forward. How do we prevent excess? And excess here is critical to the discussion. And excess is directly related to the ticking time bomb exception, and that's why I take such great exception to the exception. Because the moment we say to ourselves, well, maybe, there is that one guy who knows where the bomb is, and because there's that chance that one guy may know, we therefore will establish this ticking time bomb exception. It ultimately is nothing more than beginning the process of going down a slippery road, and not even Superman, once he's on that slippery road, can get off of it. And if Superman can't, none of us can, including the government. Two other thoughts with respect to this entire discussion. There have been those who have suggested in the context of this post-9/11 world that we need to adopt what is called the unitary executive theory. The unitary executive theory suggests that in times of war, combat, the executive need not be challenged, that there need be no judicial review, and there need be no congressional oversight. I would suggest that it is precisely when America is engaged in combat/war because there is no war here, it is precisely at that time that there must be very strong independent judicial review by the United States Supreme Court. And there must be very active congressional oversight. Judicial review and congressional oversight enable a monitoring and a review of the executive. Because otherwise, the excesses of the past 7 years will repeat themselves. If you think about judicial review in the context of coercive interrogation, it suggests the following: that if the head of the relevant agency authorized, and if the detainee and or his attorney felt that the interrogator engaged in excess in the context of the interrogation, that will be reviewable by independent judicial review. In the Israeli model, it's by the High Court of Justice. And I would suggest that there is no reason why the United States Supreme Court cannot engage in the same kind of active, independent judicial review in real time to prevent excess. And if you look at this very carefully, you will see that the most important case, Hamdan, was issued 6 years after 9/11, or 5 years after 9/11. 5 years after this individual was detained, the Supreme Court finally rules. In the context of lawful operational counterterrorism, that 5-year delay is untenable. With respect to the Congress, I would suggest that here too, there needs to be a serious ratcheting up of congressional oversight of the executive, precisely in order to minimize excess. I won't say to do away with all excess, but clearly to minimize. How then, to finish before we turn to questions, Ben, you said we have time for questions? The entire point of this coercive interrogation regime with respect to the hybrid paradigm based on the Israeli model is to enable as much as possible the establishment of a paradigm that is lawful and moral. It grants the interrogators enough skills or enough rights to be able to go about their responsibility. It protects the detainee, and it ultimately, and maybe most importantly of all, it protects us also. Because you have to think about how our misactions will ultimately affect us, not only from a perspective of foreign policy, but also in terms of the court of international opinion. So if you view this all together, here's what I suggest you take away. One, that interrogations are absolutely necessary to counterterrorism, but that the existing interrogation regime, rather the criminal law interrogation regime is inappropriate, inapplicable. Torture is clearly out, and the coercive interrogation regime reflects a balanced approach predicated on a hybrid paradigm, enabling the interrogators to more successfully, more legally, and more morally to go about interrogating those who we need to interrogate. Does that mean that there will be no more excess down the road? The answer is clearly no. Mistakes happen. But my proposal suggests that this is the most effective way to minimize mistakes while getting the information we so very much need in order to conduct lawful operational counterterrorism. Thank you very much. Questions? Sir,
Yes.
put this water there.
So you propose that certain coercive techniques be used on detainees in advance of the trial. It seems to me that those techniques, like sleep deprivation, would be unpleasant enough that they would be considered a punishment. So my question is, how is it constitutional to punish people before they've been tried for a crime?
I would not view sleep deprivation as punishment. Punishment, I think, is precisely the role of the courts. I would view sleep deprivation, in addition to the 4 other measures I discussed, as measures that are appropriate to an interrogation paradigm that enable the interrogator to get the information. I don't think that the detainee or the interrogatee is being punished there. I think it's a way to get information from him in order to determine whether or not there's enough information to go forward with the trial. I would not view it as part of the punishment. I'm sorry, I wouldn't view it as part of punishment.
Okay, thank you.
Thank you.
Hi. You mentioned a number of times limits on the amount of time certain interrogative techniques might be applied, how long someone can be detained before being to trial, but you haven't given any indication of what you think those time limits ought to be, or what is the objective way of determining what's an appropriate time limit. Like, when should we release someone who's been detained indefinitely, or how long should we sleep deprive someone?
It's a great question. I'm sorry I didn't address that. First of all, the coercive interrogation regime is predicated on independent judicial review, meaning that the interrogators need to bring the detainee in front of a judge, be it every 2 days, every 5 days, every 8 days, in order for the judge to determine whether or not there's cause for continued remand. If the judiciary determines that there's insufficient cause for continued remand, the individual will be released. Meaning that unlike the present regime today, where it is in essence indefinite detention, the coercive interrogation regime is predicated on the judiciary allowing the state to continue to detain the individual, and if there's insufficient information, the individual will be released.
Okay. Another, maybe 2 questions, actually.
But one at a time.
Okay, yeah, one at a time. Under what circumstances are you proposing that someone be put into this extra sort of intermediary process? You know, what standards have to be met before someone is interrogated or is put into this terrorist, system rather than a normal criminal system? You know, what boundaries have to be met before that's applied, and what rights does the individual have to challenge that determination about which system they're in?
First of all, there's a whole other subset to this entire discussion, and it is what I call the objectification of operational counterterrorism, which is criteria-based rather than leaving it to over discretion.
Mm-hmm.
If the interrogator, based on intelligence information that he believes is valid, viable, reliable, and corroborated, is convinced that the individual knows more than he's telling him, that is when he could request permission to adapt or implement the coercive interrogation regime. It cannot in any circumstance be the beginning of the interrogation. It's only after the traditional method has proven itself unsuccessful with respect to that particular detainee.
Mm-hmm. The request of whom?
Written authorization from the head of his security agency.
Oh, so his immediate superior, no external authority?
Not
Okay.
his immediate superior,
Okay.
but the head of the agency.
Okay.
So in my paradigm, here in the American paradigm, the head of the director of the CIA would be the only one who could authorize the implementation of coercive interrogation on a particular detainee. Mm-hmm. Written authorization precisely in order to guarantee what I mentioned earlier, responsibility and accountability. How can the detainee challenge it? The detainee will be represented by counsel of his choice. Mm-hmm. And because the state is required to come before a court every few days based on what I mentioned earlier, when there's a remand request by the state, he's represented, and his counsel, just like in any remand hearing, can argue that his client has been held X days, nothing has come forward, and request the court to release him. And that goes to the essence of what I mentioned earlier of the independent judicial review of coercive interrogation.
Okay.
I was just wondering what controls you were proposing to prevent criminal evidence as being misclassified as intelligence-grade evidence so that somebody could, in fact, be put down the road for enhanced interrogation.
Correct. In the domestic terror court paradigm that I proposed, which I testified on in front of the Congress, I suggested that it's the role of the courts to determine whether or not this is criminal evidence, or this is classified information. The role of the court is to minimize what is determined or deemed to be classified and to make every effort to declassify and to make it into criminal evidence. I can tell you that during the course of my 19-year career in the IDF, I sat in on numerous cases, what we call administrative detention hearings, where an individual is not brought in a criminal process, but in an administrative hearing based on classified information. And the role of the judge, at least from how I perceived it, was to make every effort to convince the state to declassify and to turn that information into criminal evidence, thereby giving the individual the right to confront his accuser.
Okay. This seems to put a fairly large burden on the judiciary. How do you propose, or any ideas on improving the throughput of the judiciary? Because I can't really imagine, the Supreme Court wanting to hear arguments from, hundreds of lawyers and their clients all day about, I've been imprisoned and slightly tortured for a week now. Let me go.
The role of the judiciary is critical to this. And to answer your question, in the domestic terror court proposal that I've suggested, it requires establishing a new court, because it's not traditional Article 3 courts, it's not the military commissions, it's something else. Those judges will be the ones before whom come these individuals. Is it an extra burden for the judges? I don't know. But the role of the judiciary is to be an independent judiciary, engaged in determining whether or not the actions of the executive are lawful or not. I would suggest that 7 years later, what is clearly missing in this entire debate is just that, truly active, independent judicial review as is practiced in Israel by the Israeli High Court of Justice. And I think that my domestic terror court, call it almost like a district court, equivalent to a district court, with appeal to the United States Appeals Court, would guarantee that two-part independent judicial review. Yes, sir.
I don't understand if harsh measures like waterboarding are not effective enough in getting true information, how would softer measures like sleep deprivation and the uncomfortable seat will do?
I've never seen anybody waterboarded, but having spoken to people who are involved in the interrogation process, as I mentioned earlier, most, not all, there's never all, most, if not many, will tell you that an individual who is waterboarded, the information he gives is not actionable. The poster child for waterboarding is Khalid Sheikh Mohammed, and there are those who suggest that the information he gave while being waterboarded is inaccurate. What he gave when not being waterboarded is accurate. With respect to the five measures I discuss in the book, these 5 additional coercive interrogation measures, having seen people exposed to those, or having seen people whose those measures are implemented with respect to them, my takeaway, based on my experience, is that those measures are successful. They are, if you will, they are conducive to the detainee providing information. I also, based on my experience, feel that when an individual is subjected to those measures, what he says is correct. Because one of the realities of torture is that somebody who's being tortured will tell the interrogator what he thinks the interrogator wants to hear in order to have the torture being stopped, and that's the inactionable. So that's why I think, well, first of all, waterboarding is just off the charts, over the top, illegal torture. The other measures are not, and I would suggest that the other measures, when conducted or implemented accurately, correctly, subject to the conditions I mentioned earlier, lend themselves to successful interrogation.
You didn't actually specify in your list of these extra 5 measures any permanent damage, because both loud noises can lead to permanent damage of the eardrums, or even just slight hearing loss. And of course, sleep deprivation after about 5 days changes a person's personality, and they can actually become psychotic. Right. Do you think that's within the bounds of acceptability or not?
First of all, with respect to the loud and cacophonious music that I mentioned earlier, having been exposed to it myself for, I don't know, I lost track of how many times, it's unpleasant. The music is also terrible. I mean, it makes rap sound like Beethoven. I mean, it's just terrible stuff. I never felt that I, or people who were exposed to it even more, interrogators, I don't think any of us ever suffered any permanent hearing loss. With respect to sleep deprivation, Geneva Convention talks about giving the detainee 8 hours sleep in a 24-hour period. Nowhere does it say that it has to be 8 continuous hours. One of the purposes of sleep deprivation is that it affects the REM cycles. I mean, we all know when we're tired, we have a tendency to say things maybe we didn't really want to say. But here too, and I'm sorry I didn't mention this earlier, the sleep deprivation in the context of in the context of coercive interrogation is also time limited. Precisely in order to avoid permanent loss, permanent personality, or affecting permanently the individual's psychological makeup, is intended to, on the one hand, it's balancing, to enable the interrogator to get correct information, but critical here, not in any way to permanently affect the individual.
So why do you think that being waterboarded doesn't work, and yet having a sack put over your head or loud music played all the time is effective? I mean, you say you've observed, but why do you think it actually works like that?
Because I think when the individual is being waterboarded, and I emphasize, have not seen anybody being waterboarded, but having spoken to people involved in this, having read all the accounts, when you're having the water, the pitcher poured into your mouth, and you think you're going to die. No disrespect to you, but I assume that if somebody were to pour pitcher after pitcher of water into your mouth, you will tell them that, whatever you think they want to hear. Because there are no limits. It's beyond the pale. The other measures, when implemented piecemeal, in a limited fashion, subject to control, have lent themselves clearly to receiving information proven to be correct.
But I'm asking, why do you think it works like that? Why do you think the second class of techniques doesn't lead someone to say anything just to get out of it?
Because I think that having spoken to Israeli interrogators on this issue, what they will tell you is very interesting. That the interrogator will respect you if you keep the interrogation within boundaries. And if you engage in excess, he won't respect you, the information he gives is not relevant. But within the context of a relationship, of a controlled relationship, a dependent relationship between the interrogator and the interrogatee, the information received time after time after time has proven itself to be accurate.
So thanks for coming here. I think this is a really good discussion, and it's at a much higher level than what's actually happening right now. So that's positive.
Here comes the but.
Of course. So otherwise I wouldn't be here. My question is, all this is extremely one-sided. So there's always the issue of foreigners being detained here. Would you be in favor of these measures being accepted by, say, Thailand or China, so that when a French or an American tourist is in China or in Thailand, or he's there for business, and he goes missing for a week, for 2 weeks, his children don't know where he is, and then 2 weeks later he finds out, oh yeah, it was all fine, I was being interrogated, they didn't do much to me, but now I'm back home. So you can apply these to America, but would you also be willing to apply this elsewhere? And Are we okay with that?
No, I'm okay in applying these measures only in civil democratic regimes where I know that there is active, independent judicial review and strong, powerful, consistent judicial oversight. They can only be implemented where the actions of the executive are subject to, and I can't emphasize this strongly enough, to active, independent review. Because otherwise, it is all but certain that the executive will engage in unchallenged excess, which will lead to clear violations of human rights, which ultimately not only illegal, immoral, and so on, but would destroy the very foundation of what we're talking about. When I chose the title, constitutional limits on, it really is constitutional limits. In the American paradigm, it's the 5th, the 8th, and the 14th Amendments. Precisely in the context of separation of powers, precisely in the context of balance of powers, because otherwise implementing or allowing the implementation of such measures is a surefire guarantee for that slippery slope, and where there is no review, where there is no congressional oversight, is going to lend itself to just horrific violations of human rights.
So, I don't understand if the torture is so unpleasant that's going to give people the inclination to give misinformation. Why would it be different for the sleep deprivation, the music? If it's so uncomfortable, why wouldn't they be just as inclined to just say whatever will placate their interrogator?
I wouldn't use the word, I think you used the word unpleasant in the context of torture. I mean, torture is far more than unpleasant. Torture is in terms of the 1984 Convention Against Torture's definition of it, is excessive pain, mental, physical pain. I mean, that's what torture is. It's excessive physical and mental pain. Sitting in an uncomfortable chair, the kind of chairs we all sat in first grade, it's unpleasant. It is in no way excessive pain. It is seeking to articulate or to balance, to implement a balanced approach.
But I mean, something as simple as being forced to sit in one position for long enough will eventually become torture. I mean, to the extent that it'll even do permanent damage.
Again,
it's all a
it
matter
goes
of
back,
time.
taking your question, Ben, and returning back to somebody else's question. All these measures, and this is critical to the discussion, are time limited. In the context of what I call, again, not to repeat myself, the objectification of counterterrorism requires clearly implementing time limits on which measures we impose on individuals.
I understand you have another book coming out later this year. Can you discuss that?
I do. The book that's coming out in November is called Fundamentals of Counterterrorism, published by Aspen, in which I address counterterrorism from the perspective of 11 different issues in an effort to provide both various audiences, policymakers, decision makers, academics, Google, with a broad analysis of counterterrorism in order to help all of us better understand the issue. So this book, Constitutional Limits on Coercive Interrogation, is specifically about interrogations. The next book, The Fundamentals of Counterterrorism, it takes a broad view, speaking about numerous issues about counterterrorism in order to hopefully provide the reader, general audience, a more a broader view of what counterterrorism is, in order to better understand what I suggest is the most important issue of not only of our day, but frankly also of our children's day.
Have you given any thoughts to what if the interrogatees fight back? And what limits there are on how they will be then treated?
By fighting back, you mean like trying to punch the interrogator?
Whether it be, if they've been placed on an uncomfortable chair, getting off it, breaking it, doing whatever there is possible within physical means to prevent it. If that includes, fighting back, punching, tearing an ear off. I can imagine if you're in that sort of situation, it's just kind of like, screw you, I'm going to do as much damage as I can. It's because it is a gross violations of someone's personal dignity, and there's a point you kind of say, it just doesn't matter anymore, I'm just going to take it out what I can. But that, of course, will enrage the interrogators.
I think that an interrogatee who tries to break a chair or tries to engage the interrogator kind of violently needs to be restrained. I would probably suggest that the interrogation be stopped at that moment, and that there are various sanctions imposed on detainees in any incarceration setting. Impose sanctions and come back and hopefully on a better day. That being said, in no way does the interrogator striking out at the interrogator justify the interrogator striking the interrogatee. In no way. It's all about restraint.
Okay.
There are no more questions. Thank you very much.
Thank you very much. Thanks for having me.